في اشياء رقميه اشياء كل شيء يعني ليس
Good afternoon. Let's start. That is marking you ahead. Mark the business. Right. Till first I wish you all the happy 2026. And we'll start with the topic. Officers of the company will start with the directors and their duties, and then we discuss about the auditors and secretaries. So those are the subtopics that we will learn under this topic. So directors, the meaning of a director, different types of directors, maximum and the minimum number of directors, their qualification, right? And yes, delegation of powers, major transaction. And as a second part of the lesson, we discuss about the directors' duties. Yes, out of these three, first we will learn about the directors, and then we can discuss about the secretaries and auditors. Right. We all know that company is a separate person, and we also try to compare the company with the human beings. So company has a name, it has an address, and even it has a birthday. So, however, we can find the brain of a company. So we can assume that director or board of directors are the brain of the company. So we expect them to think wisely, act honestly. So therefore, they are the people who transfer the company, transfer business, but sometimes even some directors don't know what they are and they. So however we discuss those discussing about the directors, they may be the heroes of the company and sometimes become the obsessive anything that we'll see their appointment, duties, termination of office qualification and all. We'll start with who is the director? What do you think? Who are the directors? The person who has the time and shout at the meeting is a director. You know, you get the director here. What are they going to get directors around? Basically, we are ties and shout at meeting, right? So we call them directors, is that correct? Simple there. If a person is in the data head or some other document as a director of a company, but they never come to the company or company, so acquisitions are the directors. Yes. They are directors. Even if they don't take patients or come to the company, their name is in some documents, they are directors. By the way, I have done it to the directors, even if they don't come and participate in the meetings anyway. Then how do you? Okay, that's clear. But it's your opinion, who is implemented?
The company appoints him from Form 18. However, they are directors, whether they came or not, they are directors because they are appointed by shareholders.
You'll agree? If a person never been appointed by the company, so file the Form 18, but they take all the decision of the company or advise the board, then who they are the directors. Even the so-called appointed directors by shareholders act according to the instruction of that person. What do you think about it? That they never been properly appointed. No file with Form 18.
Maybe they will be in other positions. For companies, registered companies, director is for the specific person who are appointed legally by from Form 18.
Right. English common law recognizes two types of directors. English common law recognizes two types of directors as de facto directors and the jure. De facto directors is the directors, they are so properly appointed as you say. The jure directors means the directors, they were never properly appointed, but still, so recognize them as a director. So they recognize two types of directors. Therefore, directors may be properly appointed, like passing the solution, so by the filing forms, and maybe not so properly acting. But according to common law, they recognize both as the director. Sometimes compare me recognize, but whenever there are issues before the court will never look at the formalities. Okay? But true nature. Right? True nature of their role. Not what they were, not forms, but whether they actively are reacting. So therefore, the act by section 526 interpretation section gives an interpretation for the term director. So that interpretation clearly within the meaning of the English common law, it includes both properly appointed directors and not so properly appointed directors. Right? Accordingly, it widely says director includes a person occupying the position of a director of the company, whatever name. Right? Therefore, director is a person who is in a position of a director, whatever name for. Therefore, their name is given. Their name may be director, managing director, governor, CEO, John Paul. Name is given. On the other hand, even though name says director, the person won't become director. Become director, they have to be in a position of a director. There are some private business, they have some positions like director transport, director finance. When you ask them about the name at the boardroom, they never know it. They never been there. Right? But the question is director transport. They only have the process and the conductor of the planes. There's nothing to do with the board and decision making. But the question is director transport. Therefore, just because of the name or title is director, person won't become director. To become director, person has to be in a position of a director. So, what is the director position? That will be decided by the court in merit of each case. Right? So, basically, they have to take decision on behalf of the company. So, basically, according to another case, the court decided that director's position is that someone is a director, they have to attend the board meeting. And also, they have to take a decision at such a meeting. If a person basically do those two things, attend board meetings and take part in decision making at such a meeting, that is generally the position of a director. If they do so, then their name is in. So, accordingly, the section 529 gives the extended meaning for the term director. It says director includes the person in accordance with whose directions or instruction a person is accustomed to act. They are known as nominee directors. Sometimes when there is a institution like bank, right, if they have given some huge loan amount to a company, to safeguard their interest, sometimes they send their nominee to a board meeting. Right? They are basically to safeguard the interest of those companies. So they are known as the nominee directors. And director also include a person in accordance with whose directions or instructions the board of the company may be required or is accustomed to act. It means there are persons, they don't need to be shareholders. They don't need to be director. Simply they don't want to take any responsibility. But they are the people behind the scene, they control you. Maybe even the money and the whole business belongs to them. But they don't disclose it. Right? So they instruct the board. They instruct the board how to do what to do it. Sometimes they use outside the common field, they use the title as it. But they were never appointed as a director by shareholders. So they were never signed any form. Right? So they are known as the shadow directors. Right? The board acts according to those people's structure, but they've never been appointed to. One good example would be someone in the about 10, maybe 7, 6 years ago, there was issue the director whether Rohit Rajapaksa was a director of CSA. Right. I don't know what happened, maybe still they are fighting. Right. Because he never filed a permit. Right. He was never appointed as a director. But everyone knows CSA board act according to the instruction of Rohit Rajapaksa. Right. Sometimes he has even used the title managing director. He makes some other business status. But when you want to find whether they are directors, as you said, there's no information. So there are issues whether he was a director or not. What do you think? He's not a proper director, properly appointed director, but still a director, right? So they are known as the shadow directors. Right? Shadow directors. So then director also include the person who exercise or who is entitled to exercise or who control or is entitled to control the exercise of powers which would be required to be exercised by the board. Right? So if there's any person who exercises the powers of the board, right? Maybe with the consent of the board, maybe without, right? Maybe say as an example, manager or director of finance or CEO, right? The board gives some of their powers to CEO. But he was never, he's not a member of the board. Board gives some of their powers to the secretary or some other governing person or committee. Right? So law says they are also directors. Right? So they are in fact sometimes if it is yes, it is required to be exercised by the board, but these people exercise those powers. That's so. Law says they are also directors. Right? Therefore, if a person exercises the powers of the directors include decision making, right? Or maybe appointment of some other people, officers, right? Or maybe issue of shares, they are definitely with the other directors. We said the consideration to issue shares. Right? So if the person exercises those powers, they are also directors. And last it says, director also include the person whom a power or duty of the board has been directly delegated. They are known as the delegated directors. Right? Because law recognizes that the board can delegate their powers to a person or committee. As an example, as to recognize the appointed by shareholders. But in many companies, shareholders have passed a resolution, the board can appoint the other director. Then there's what the board can do, they appoint a nominee committee. So they can nominate the other directors. So they exercise the powers of the directors. Or audit committee, salary committee, nominee committee. Likewise, they can appoint some other people other than managing director. Right? So they can appoint the person and delegate some of the powers. Or maybe see. Right? In such a case, they are known as the delegated directors. So those all include within the name of the directors. Right? So therefore, director has a very wide meaning. They are not limited to the person who sign Form 18 or follow formalities. So director may be not so properly appointed. Accordingly, there are different types of directors. So as I said at the very beginning, basically law recognizes two types of directors as de facto directors and the jure directors. That is the directors so properly appointed or not so properly appointed. So, and then there are executive and non-executive directors. Who is executive director and non-executive director? Or the executive director? මේ වගේ කට්ටියනේ හැමදාම ලැක්චර්ස් දෙනවා නේ හැමදාම කම්ප්ලීට් කරගෙන බලන්න ඇක්ටිව්ලි කරලා පාස්පෙක්ට් කරනවා එක්සර්සයිස් කරනවා කතා කරනවා full time වැඩ කරනවා නේ sometimes even the helper may have given them up yes contract as an employment contract as right. So they are most probably shareholders as right. So they are known as the executive directors non-executive directors you know exactly maybe this is some of the and then you like them very angry and they will okay you know first chance and go non-executive directors they are basically hired for their expertise and also there's another type of director known as the independent director. Who are the independent directors? Independent directors are from executive or non-executive directors. Can executive director be an independent director? They are basically non-executive directors. Independent directors are also appointed for their expertise. So they are there to check, search whether other people do their office or job properly. Right? They will check. Independent directors are there to check whether all other directors doing good properly their job and whether they take wisely actions and all this because especially they are there to incorporate their expertise. Right? So those because not all directors are expert in everything. Therefore, to fill that gap, board can recruit the independent directors. How to decide independence is again up to the company. Only thing is it has to be disclosed through the annual return in the PH. Basically, it's good if they are not shareholders, but some companies believe if they have less than 5% shares, they can be independent. However, if they have a considerable number of shares or some other relationship, or if there is a close relationship for family members or whatever, obviously they are not independent directors. Then shadow directors, as I told you before, right? So the other directors, they control the board document. And the board, as a practice, follow their instructions. They are known as the shadow directors. But that also can happen with the controlling shareholder. Within that, there's a company, it has 100 shares, 80% shares to 1%. Let's say X. But X does not want to be a director. Therefore, we appointed Y and Z as a director. But A has 80%, he controls. Known as the shadow director. So managing director is he is also a member of the board. And basically, it is also common in business to have a managing director. He has a dual role, like in one hand, he is a member of board. On the other hand, he is an employee as a company. So, for the managing director, in many companies, the board has given extra powers, so delegated some of the powers as a managing director. Alternate directors are there when the one member of the board go abroad, temporarily unavailable, then the board can appoint the alternate directors to fill that gap. So nominal directors are basically appointed by the financial institutions of bank to safeguard their interest. So those are some type of directors that you can see in the business world. However, for the law, the judges don't like to discriminate or categorize the directors. Rather, they love to see them as a board of directors. But they believe is all the directors, regardless of their category, shall be equally liable for the decision of the company. But sometimes, when there are cases, they practically don't use it. But they don't let others to know that that the independent directors are less responsible and all. It is not in their opinion because what they believe is if you cannot take responsibility, you better to leave the company. As long as you are a member of the board, all board members are equally liable for the decision of the board. Right? But practically, we can see in the case of court orders and all, there's a trend that the executive directors may be more liable than the independent director. But they do not accept it as a principle. As a principle, there are no different types of directors. All are equally liable or responsible for their decision. But in business world, we know that there are different types of directors. Right. The importance of directors is that probably you are aware that you can't incorporate a company without a director. You can't run a company without a director. In fact, there will be no meaning for the director. Companies, there are no director. And without a director, companies like a Iron Man suit. Right? Iron Man suit. There are muhut karane bhai. Milke ko karne na. Ne? Evagi tama director say kato our પાસે tama it can act. So therefore, you can't start the company or run the company without a director. If there's no directors, it is even a reason to wind up the company. Law does not only say that there must be a director of the company, it also set out the minimum number of directors as. Okay. What is the number of minimum directors? Minimum number of directors of the company? 1. Yes. Company is also be acting on 1. Any type of company. Yes. Well, you all believe that minimum number of directors of the company is 1. Public company 2. Those law says public company should have at least 2 directors. At least 2 directors, whereas any other company should have at least 1 director. Therefore, the minimum number of members of the directors of the public company is 2. Okay. Any other company with a private guarantee or whatever, those type of companies may have 1 director. So, maximum number of directors. Is the maximum number? There's nothing in the Companies Act, but there may be some clauses by the articles of the company. Articles may have some of the seating, right? So minimum is 5, maximum is 50. But there are some countries, there are some codes like good governance code, best practice code. They say the ideal number would be around 20 or between 15 to 20. Okay? Because you can't have some number of people, right? But there's no maximum limit by the Companies Act. But with the articles of company, they can have a minimum and maximum number of directors, but minimum can be less than the Companies Act. As an example, you can't say that minimum number of directors is 1 for the public company because Act says 2. Maximum, the Act can decide, the article can decide. If there's nothing in the article, there's no maximum number of directors of the company. Who can act as a director? Can you act as a director? Yes. All of you? Certificate करना है ना? Certificate तो ना दे बोलो आपको केवल तो and then if you act as a director, how do you know that they are mentally okay? Then I'm again by not accept. So like who will decide that you are mentally okay? But the thing is good to have some qualification or that is. These are very so it says he believes that any person over 18 can be a director of a company with a good financial background. If you have good financial background, but it needs a financial background. Yeah, but they don't have a background or whatever. Okay, good try. So, what do you think about that? If you go through the qualification of directors, in fact, the act does not require a formal educational or professional qualification. So, in fact, act set out the disqualification, it's more than the qualification, right? So, there's no requirement of any formal or professional qualification. You can compare it with the requirement of audit and secretary. Okay. To be auditor, there are some must requirements. To act as a secretary, there are some requirements. Then we academic and professional qualification. But to be a director, there's no such requirement. But do you think not having such a requirement, is it good? Or is it good to have some type of qualification? Who is it? Or the people are modern, natural content.
They have qualifications.
We can have qualification.
Awesome.
Who is it? And see, member, any person on that? Here's the best product telling reality. Then I look at it. Anyway, I think it's good the people have done a better job in drafting that without asking any type of professional and academic qualification to have that great, right? Because if you look at the proper business people of the world, none of them have a so-called education or professional background. Right? Jack Markia ने की पारा इसमें जो पेड़ गाछ करती है नहीं वो लोग की पारा आज इसमें जो पेड़ गाछ तो पेड़ इतना तो बड़ा वो लोग बिजनेस करना है But there was a man who just like I can proceed love, right? Lanka, the reality, but the reality, they have started a government for people, but they hopefully not possible. Then, yes, so they are both. But they are in some picture, right? But it doesn't mean that they are in. They are very good disciplined people with a very good background of that business and so that is why there's no relationship with the business and the education. Right. In fact, do you think that those people in your lecture panel or board name, do you think that we can do business? For example, for that time, what I dare, what I business cannot work here. The professors are set up business cycle now. When we go to the youth, something I can never talk about. This is not the it's a different art. So that is English norm. Relationship, so that said that no, some formal requirement of education law, professional qualification, according to the qualification of director. However, it doesn't mean that any idiot or criminal offences people can act as director because there's a disqualification. This it says first they must be over 18 years of age. So that means that there must be some type of maturity. It is anyway the legal age of entering into a contract. And it says an undischarged insolvent. That's right. Financial bankruptcy, bankruptcy, insolvent. That is also a disqualification to contract. And then prohibited from being a director under the Companies Act of previous Companies Act. Companies Act disqualify people becoming directors if they are guilty of a criminal offense, then they can do it. Or if they have done some criminal offense for under the Companies Act, like giving untrue statement in prospectus and all, then the company can disqualify. If a person has disqualified as a director of the company, then they also cannot act as a director. So definitely they have to be some people with good discipline and not related to the criminals. And also, yes, unsound mind, right? Insane person cannot act as a director of a company. That is, but that must be decided by the court anyway. Court really decide a person as an insane person. And only the natural person can act as a director. What is meant by natural person? To be a director, you have to be a natural person. What is meant by natural person? AI people, robot can. Natural person. Yes, because a natural artificial person. A company cannot act as a director. Only individual can act as a director. So company law recognizes two types of directors as natural directors and the artificial person and natural person. So artificial persons are the corporate bodies. Right? A firm can act as a auditor. A limited company can act as a secretary. But to act as a director, you have to be individual, natural person. For natural persons, individual can act as a director, right? Limited company get a back, firm get a back. And also does not comply with any other, yes. There may be some other qualification by the articles of the company. Right? So some articles provide that to be a director of our company, you have to buy a share qualification. Right? You have to buy 10,000 shares or 12,000 shares to be a director of our company. Likewise, there may be some other qualification imposed by the articles. And also under section 213 and 214 of the Companies Act also prohibits some people, especially these two sections are related to the people who has done a crime. Right? Therefore, even though there's no requirement of professional academic qualification, you can see people who are related to the crimes, right, or other offences, or any offences of the Companies Act, right, or minors, insane person, bankrupt person, they cannot act as a directors of the company. Therefore, only the people with the good business background and ethics can act as a director of the company. And also, if you believe that companies need some type of people in some professional law, educational law, academic background, that is right. The Act has a position to recruit the or to have a independent directors. Especially PSCs, there is a must requirement that either two directors or 1/3 of directors must consist of independent directors, whichever the higher. Right? And salary committee, nominee committee, audit committee only must consist of the independent directors. So those independent directors anyway hired for their expertise. Therefore, those chartered accountants, lawyers, doctors, right, whoever you can appoint as the board members as a independent director. Then there will be some balance between the business and professional activities. Right. How can we appoint directors? How to appoint directors? Who appointed directors? Shareholders. Board. Who has the authority power to appoint directors? According to the Companies Act, that power is a power of the shareholders, right? It's a power of the shareholders, but it always says subject to articles. So by articles, even a person can be appointed as a life member of the board, right? Therefore, it is always subject to the article. If article says this person can be a director, until this director, whatever, right? So article can appoint a person as a director, subject to the articles. Directors are appointed by shareholders at meetings, passing only resolutions called for that purpose. Right? However, first directors, initial directors are not appointed by it. Because to incorporate a company, you have to have a directors. Before incorporation, there are no shareholders or meetings. Therefore, the first directors are the directors whose name is in the application form as a first directors of the company. Those people will automatically become the first directors of the company. Therefore, first directors are not appointed by anyone. The person's name appears as the initial directors of the company in the application form, automatically become the first directors of the company. Then at the first AGM they have resigned. Thereafter, all other subsequent directors are appointed by shareholders at meetings, passing all the resolutions called for that purpose. However, there are many PSCs where shareholders appointed few directors firstly at the AGM. Thereafter, they pass a resolution giving the authority to the board to fill the other vacancies. However, that authority has to come from the shareholders. Shareholders have to give that authority to board to appoint the rest of the directors. Then if shareholders pass such a resolution, then using that power, then the board will appoint the rest of the directors. So that is how practically it happens. Right? And if company has to appoint 5 directors, can it be done by one resolution? Or you need 5 resolutions for that? If a company wants to appoint 5 directors, Directors have to be appointed or voted individually, right? Even at the Lama can be that case. In some private companies, you may be able to appoint all directors by one resolution. But in all other cases, they have to vote it individually. Those resolutions has to pass separately. Voted on individual companies other than the private companies. What will happen is there is a person of the board who was not 18 years of age or who was not appointed by passing proper resolution. What will happen to the decision they have made? There are 9 members of the board. 1 member was a son of the managing director who was just 17 years of age. Then the company has taken a decision where that man was also a board member of that meeting. What do you think about the decision taken at such a meeting? Are they valid or void? So they have entered the contract to start some business in the port city of Ireland. What's the validity of this contract, you think? A decision is taken at a meeting where one director has no qualification or not so properly appointed. A board decision is the monabit, valid the void to a valid, not invalid. Where is that one? Valid. You? Board එක ගන්න තියෙන එක board member කෙනෙක්ට ඉන්න බලයක් නැහැ නේ. එයා පළේට අපොයින්ට් කරලා නැහැ නේ. අවුරුදු 17යි. මොකද the decision is valid or void taken by the board where one member has not qualification. Practical reason. So you have taken them. You can also use the agency law. දැන් මේ වගේ වෙලාවක contract එකක් එහෙම ගහලා තියෙනවා. දැන් අනිත් පැත්තේ කට්ටිය දන්නවද මෙහෙම බෝඩ් එකේ විස්තර හොයනවාද අපි සාමාන්‍යයෙන්? ඔයාලා හොයනවාද ගිහින්? මුංගේ නම් ගම් පියවර විස්තර අපි හොයන්නේ නැහැ. We reasonably believe that they have been properly appointed and they have authority to enter into pass solution, right? So therefore, the third parties can reasonably believe that they have authority. If they have authority, then the company is liable. Right? Otherwise, it's not practical to reverse them. There's an example, and one time, one of the chief justice was after 1 year decided by the parliament that he was not so properly appointed. Mohan Srilanka, Mahendra appointed Karadula, Japan Aila, Silsera, Ainkaram, parliament. He was not never been properly appointed. Then the Shirali Bandari was reappointed. Right? Because the appointed Shirali Bandana reappointed Kalaya by the Sakita Gayane. The Kali Kirupik අයින් කරනවා. properly appoint කරන්නේ නැහැ කියලා. ඒතකොට එයා CG වෙලා ඉන්නකොට දුන්න decision වලට මොකද වෙන්නේ? හිතන්නක CG වෙලා ඉන්නකොට කාට හරි capital punishment එක දීලා. මිනිහෙක් මාරු. මොකද වෙන්නේ ඒතකොට? ඒක අපෝ ගන්න බෑ නම. It's not practical, right? So even though from that date he was not entitled to act as a chief justice, but the act he has done during that time is still considered as an. Otherwise, it is not practical. Likewise, even though there are board members, they have no qualification or they never been properly appointed. The section 209 says the decision they have taken must be valid. And they must be considered as valid decisions. They are valid, otherwise it's not practical. Especially, it's not good for the third party. However, they may be different if the third party is aware of that defect. Third party is are they entitled for the salary or what is the salary of directors? How much they are paid? Directors or someone in Kotsya for the payment they have done now. How much they are entitled to? What they get carry someone in Kotsya. But it's a big one day to be a director of a company or like is that for the systematic other chartered accounting right now. So that's why it's board member direct medical and the one right. However, the CAG, if there's nothing to be done, it will go to the end. Shape the now, make transfer Galle at the 1,000 times. Everything. Whether then not pay tax rate available. Transfer of I saw about 20 years. Some problem. There is sometimes 5 in the morning or sometimes they can participate in the the special account they did this and that's something to a safe to living up and do that and it's 8 yes. Sometimes in the station when 24 hours. Again, I'm not there to but very young people, I think. It's a right. 8-hour work is not up to it. It's a right. Especially for young people, I think. Again, I do not like work for me. Not for the life. They get the daily. Feel about Canada, relax, everything. The life they got married about. How do you that is now it is 2 years of change. I have to know how to do it. Then not 3 years. No, but there is another one. So 4 years. 4 years to repair. Budu that the other part. Then ඉනිම කෙරුවා කියලා උගලට අවුරුදු 4 වුණාට පස්සේ ඔබ දුන්නා කියලා ආපහු කියන ඔඩිට් කෙනෙක් විදිහට ට්‍රේනින් නැහැ කියලා ආයෙත් වලු දෙක ආපහු එකමත් ආපහු එක්ස්පීරියන්ස් all for that for how much the පහළ දොරේ ඕ ආදාය අද පාරක් කියන්නේ ළමයිරු බෝඩිමල් දෙන්න නේ කියන්නේ සිපන්දහත් අතරුදානේ නේ ඒක දවස් ගන්න it was to be that so funny. ඒක නිමවනම් හැමදාම කිව්වා I know the label. Right? Our work is a right. It is not a privilege. Even though you are extending, take it or other money, get up and stay here. But I'm done with taking over place. It gets not ever fail.
පාර්ලිමේන්තුවේ නෑ 12 BBA
After that, at least now they will look at it. Then I think it's like that. Some of the I mean, it doesn't mean that you have right to ask for the 100,000 and so, but you have a work. Sure. But decent allowance must be paid for fair hours work. Right? They will go on environment, fair to the poor family. Kita kira nak apa makan itu kalau kapan ada tu kalau dah kita so ada sekali kita macam ni. Kalau tu dia tu mana dah nak teori yang ada dia lama. So they got put on there. Right, anyway. So how much they are charge the council? Oh, sorry, directors. In business world, anyway, they are the most highly paid parties, board members. Right? However, according to the law, they are not entitled for any rupee unless decided by the shareholders. Therefore, their salary or allowance must be decided by the shareholders. Directors themselves cannot decide. So basically, if there are no provisions in the articles, or if the shareholders have not passed a resolution, then they are not entitled for any salary or allowance. However, we all know that the articles are prepared by the board members. They have either majority votes or they have a control over majority votes. Therefore, they definitely will get it passed. But even by mistake, if it is not there, then it is not a right. Not a right. So their salary or remuneration must be decided by the shareholders by passing resolutions. Right? If authorized by the articles or shareholders by passing all resolutions, then they are entitled for any remuneration or allowance. Or even for the former director. However, companies must maintain the interest register. Their salary remuneration must be mentioned in that interest register. Gudakar salary wage denne ane deka independent lamai, right? Effect, right? In many cases, directors are paid allowances. Right? Because of parliamentary mandala gudak kaiwa, Srilanka ne align ke chairman ke salary. Because the ministry as the Nivasil Palvarity, there are Sata Pahaka Salika Garden to Tanwell. Yata 4 million will allowance with rising. You will some allowances, benefits, accommodation, free air ticket. Benefits the might be the but that also depends on the type of director. Sometimes some directors are even given a contract of employment. Then they become employees. Even though they are board members, some board members may become employees if the company has given them a contract of employment. But independent directors, they never will become employees of the company, so they are paid the allowances. But then how to terminate the office of a director? Global thing over here, among other than Maryland civilization. Resign, not your pension give, right? So directors terminate or vacate the office by resignation. It's a right of employees. You can resign from your post, but subject to the contract is paid. Okay. As an example, in companies, company directors, last remaining director or sole director cannot resign. Right? If a company has only one director, he cannot resign. He has to appoint another director, then only he can resign. So if there are 9 directors of a company, 8 directors can resign, but the last remaining one, 9th one, cannot resign without appointing the new director. Therefore, subject to that, they can resign with resignation. They will terminate their office. Or by removal. Who will appoint directors? Basically, directors are appointed by the shareholders at meetings passing resolution. So this is the wide power of the direct shareholders, right? So I told you even before when we discussed about the shareholders, company's power are divided by between these two. Some powers are given to basically day-to-day function, business, decision making. It's the power of the directors. But it doesn't mean that all the powers are given to me. Some powers are given to the shareholders. To approve a major transaction, right? The main such powers belong to the shareholders are the power to appoint and removal of directors. This is the power of the shareholders. So shareholders will appoint directors and also they have a power to remove. So how they can remove them? The same manner they will appoint, right? So the shareholders can remove directors by passing OD resolutions at meetings called for their purpose. Right? 51% share voting rights and removal, right? It has to be done by the shareholders. But it's not easy, as I told you, right? I can tell that shareholders can be appointed and removed by the shareholders, right? But in practical, who are the major shareholders? Directors, right? So practically, I think they control, they have the majority voting rights, or they control or they have a close relationship with the major shareholders. And it is the board, they will call the meeting. The board members, they will check the proxies. Therefore, it's practically it's not that easy, but as a theory, the shareholders can appoint as well as they can remove the directors from the post. Or maybe become disqualified from being a director if they are guilty of a criminal offense, right? Or decided by the judges according to the Companies Act 213 or 214, they are disqualified to act as a director. Then they are not entitled to act as a director anymore. Or by death. Then that's again another common method of termination of the office. Or by reaching the retirement age. Do they have retirement age? Director? No. Then CA do not prove. CA not prove, isn't it? Right. Can a person become director of a company at any age? What's the retirement age of employees? Public employees? Huh? Public employees are not retirement age. What is the retirement age of public employees? 60. All agree? Just like the latest law, the general retirement age of public employees are 60, subject to some modification. some other thing, say as an example for the lecturers 65. Supreme Court judges 65. Nurses and doctors 63. Exceptions, but generally 60. For the private sector employees, limit करना private sector की इतना vendor ने मैंने कहा मेरे साथ हैं तो private sector वाले को इतना vendor इन्हें है तो you yes probably you all will join the public sector, right? So no idea also retirement age. बता वेले जाता पहले मैं काकुल ला तो पाए और जिंदगी में खा रहा क्या ना भाई हमारे डिमेंशिया हमारे कितने हैं नहीं भाई those are very common even though you don't speak now then what is in the sun over him खा रहा right. So in Sri Lanka for the private sector there was no common or certain law for the retirement age until recently right. For the EPF ETF there was a retirement age of 50 and 55, but that's only for the EPF ETF. So this is 17 in 2021. Now there is an act called Private Sector Employees Retirement Age Act. Accordingly, now even for the private sector employees, retirement age is 60. And it is also common for both male and female. Therefore, now basically there's no difference in Sri Lanka between the private and public or between male and female. It is 60. For the company directors, companies accept out the age limit for the directors. So the retirement age for the company directors, according to section 210, is 70 years. So therefore, if a director becomes 70 years of age, then they have to retire if they are members of a public company, if they are directors of a public company or subsidiaries of a public company. Then retirement age will apply, it is 70 years. However, this law will not apply for the directors of private companies. So age limit they had there. They had there again on the ground. The sea on the ground. So retire like you would on the ground. It's all more. Galle, they will only say. Had Terry and the one. I think Kotala was a great until his death. Right. So, there are provisions, even there are fit, good people. If a company believes the company wants their service, then they can appoint them as a director of their company. However, if they want to appoint a director, it can't be like a life appointment or 3 years or whatever. Then the company's shareholders have to pass a resolution. They have to pass a resolution that this age limit, the section 210, will not apply to this particular person. Right? If they can pass a resolution that this law will not apply to this particular person, then a person can be appointed as a director of a company even after the age of 70. However, that appointment is only valid for 1 year. Right? Then if they want to get their service again and again, every year they have to pass the resolution. Right? After the age of 70, you can't have a director for more than 1 year. But in that way, when a person at the age of 80, you can appoint. For that, you have to pass a resolution that this section will not apply to this particular area. And also, they may vacate the office according to the articles of association of the company. In some companies, the article provides that every 3 years, 1/3 of directors must be retired. Likewise, if the article set out some rules, then according to that rules, they have to vacate their office. Right. Break that down. I'm going to break that down.
electric solution.
தெரியாது
Bearing. Electric.
அதாவது பேசணும்
ரொம்ப வரைக்கும். எங்களோட ஆலோசிக்க போட்டு ஆலோசிக்க மார்க்கெட்டிங் it might be such to be நான் தெளிவா சொல்லிட்டேன் இது உங்களோட மிஸ்டேக் நான் உங்களோட மிஸ்டேக் அழகா சொல்றான் என்னடா அவனோட இடையில அவங்க விட்டா பெண்டிங்ல விட்டு அவன் உடையில அப்படி சொல்லுமே அவங்க எதிர்பார்க்க செய்யணும் அவன் விஷயம் சொல்லாத தப்பு விஷயம் சொல்லாம சாப்பிட சொல்லி அவன் சொல்லலையா அவன் தூக்கம்
അങ്ങനെ കണ്ടേ അതിന് കൊണ്ട് ഉദ്ദേശിക്കുന്ന പ്രോബ്ലം ഇതൊക്കെ ഞാൻ മനസ്സിൽ ഉദ്ദേശിച്ചത് ശാസ്ത്രം முடியுது இருக்கு சரியான யாரு அடுவே 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 சாப்பிட்டு அப்படியே சொல்லுவாங்க കുഴിക്കുന്നത് അന്ന് വീട്ടിലെ ഒത്തുമില്ല നീക്കി சரி ஆனா புதிய சட்டம் அவசியம் இது கொஞ்சம் நான் வேர்கள் அடிக்க வந்தது அவனோட பேசியல இதெல்லாம் தேடும் இது வந்து என்ன கதை
We continue, right? But section 84 of the Companies Act says about the director powers. So we all know that company's power is divided between board of directors and the shareholders. Okay. Even though theoretically it is divided between these two, practically majority power definitely will be used by the board of directors because share directors are also shareholders. Right? And also they are basically majority shareholders. At least if they are not the majority shareholders, they have a relationship with the major shareholders. And also, according to the Companies Act, we can see that law has given a very wide powers to directors and obvious day-to-day function of the company is done by the board of directors. So this section, when you go through the section, you can see that the directors are given very wide powers. So it says the business and affairs of a company should be managed by or under supervision of the board of the company. Therefore, it clearly says business and affairs of a company should be managed by or under the supervision of the board. Therefore, shareholders have no say in the management of the company and business. It is a duty of the director. And it further says the board of company should have all the powers necessary for that purpose. Right? It says the board of a company should have all the powers necessary for managing and for directing and supervision of the management of the business and affairs of the company. Therefore, this section is very wide. First, it gives the power to the board to manage the company. It must be done by board under their supervision. And then it says they have all the powers and authority not necessary for that purpose. Therefore, this section has given very wide powers for the directors. Therefore, directors really have very wide powers. It's an absence of control. Right? However, there are some ways the law uses the check and balances as we already discussed. It is the right of the shareholders to appoint them. And also shareholders can remove them. In that way, there are some check and balances. However, again, we know those shareholders are again directors, right? Therefore, practically there are issues, right? Therefore, they are very unlikely to control. And only other way that the company shareholders can control them is even though shareholders have no duty to act according to the wish of the shareholder. In the Companies Act or common law or general practice, there's no law that directors have to act according to the wish of the shareholders. And they don't do. Right? And the only thing is, even though they are not bound to follow the wish of the shareholders, they are bound to act according to the Companies Act and the articles. Right? Same like the country, right? President has to act according to the Constitution, not according to the wish of the citizen. Even the companies, board has to act according to the Companies Act and the articles, not according to the wish of the shareholders. Right? However, in that way again, shareholders have a right to amend or alter the articles. So shareholders can amend or alter the articles, then the board bound to act according to the articles of association. So in that way, the board of directors have given a very wide powers. Right? Like this one, we have just started, we talk about the powers of the directors, right? So according to section 184, it's very clear that the board has given a very wide powers. It says the company's business and affairs must be run by or under the supervision of the board of directors. And next it says the board has all the powers necessary for that purpose. Therefore, by this section, the board of directors has given very wide powers. However, it doesn't say that they are not unsupervised because there are some ways where shareholders can control them. We have also discussed by appointing them, removing them, and by altering articles, use the check and balance and the shareholders can control them. But yet again, we have discussed it practically. Share directors also sit with the shareholders in the shareholders meeting. Therefore, it is unlike to control. We can say that the directors outside, yes, no one can control. They have a very wide powers. And also by section 186, Act recognizes that board can delegate their powers. Some of the powers board can delegate. Right? There were no such express written provisions under the previous Act until 2007, but it happened. But now the law clearly recognizes that the board can delegate its power to a committee of directors. So therefore, for example, nominee committee, salary committee, audit committee, those are the powers of the directors. So they can delegate their powers to committee of directors. The board can also delegate their powers to a director, managing director. They can delegate some of their powers. And the employee of the company, board can delegate their powers to a CEO or any other person, secretary, auditor. They can power some of the powers of the board. So therefore, Act recognizes that the board can delegate their powers to a committee or person or any other person. And we already learned at the very beginning, when we discussed about the interpretation of the directors, they can delegate it, then those persons become a delegated directors. So for that act, they are also liable for the shareholders and other stake, and they have to act as a directors, and they also are bound by the directors' duties. However, Act further says, board cannot delegate the powers mentioned in the Schedule 6. So there are some powers, they are in the 6th schedule of the Act. We know that there are about 15 schedules at the end of the Act, right? So 6th schedule is about the powers of the directors. So those powers cannot be delegated. We must hard on think about it. They only can be exercised by the board of directors, the real board of directors. So with that, we can also give another definition for the directors, because the powers mentioned in the Schedule 6 can only be exercised by the board of directors. Then we can give another definition for the board of directors, like when we discuss about who is the director, the real director is a person who exercises the powers mentioned in Schedule 6, because they even cannot be delegated to anyone else. So, for your knowledge, those powers mentioned in Schedule 6 include to this issue of shares. Like to issue shares, only board can do it. It can't be done by the CEO or anyone else. Consideration for shares. Then to reduce the stated capital. Right? So those type of things can only be done by the board of directors. Right? So they can be done by the delegated directors. So therefore, those main things can only be done by the board of directors, and they cannot be delegated. And we have discussed that under section 184, that the directors have given very wide powers. But the immediate next section is section 185. So that is how long when the people draft this act, they have tried to protect the third parties and strike a balance between the directors and other people, because directors are unlikely to control. That is why there are some other provisions to protect the right of other stakeholders. This is a very good example. Section 184 says directors have very wide powers. The business and affairs of the company can only be done by the directors. They have all the powers for that purpose. But then the next section, 185 says, but they cannot enter into major transaction. So for that, they need to get the consent for the shareholders. Right? So this is about the major transaction. This is very important for the auditors, right? So it says Companies, yes. What is a major transaction anyway? What is meant by the major transaction? Have you heard of major transaction? പ്രധാന ഘടകങ്ങളൊക്കെ നമുക്ക് Section 185(2) interpret what is a major transaction. Right. Section 185(2) A, B, C interpret the major transaction in financial means. Accordingly, major transaction is a transaction according to Section 185(2)(A) if the company enters into any agreement or any purchase or agreement to purchase anything which is more than the 50% of the assets of the company is a major transaction. Right. So in simply, if the company is going to buy something which value exceeds more than 50% of the company's assets is a major transaction. According to second one, B, if a company is going to sell something which has the effect of more than 50% of the company's assets, is again a major transaction. Sell or agreement to sell. The third one says, if the company is going to enter into any agreement or series of agreement which has the effect of more than 50% of the company's assets, is a major transaction. Right. Therefore, if the company is going to do anything which likely to have more than 50% of the assets of the company is a major transaction, then the directors can't do it. It is invalid. For that, Section 185(1) says how company can enter into major transaction. I've been saying you about Section 185(2)(D). Section 185(2)(D) interpret the major transaction in a different way. ABC says more than 50% of the to buy something, to sell something, or enter into contract, financial means. This says if company changes nature of business, it is also a major transaction. Now everyone says now there are no objectives of the company, right? But that is why I say it is there, here and there, right? So that is how it incorporates. If a company changes nature of business means, if a shoe company now going to sell chocolate, it's a change of nature of business. It's a change of objective. According to Section 185, it is also a major transaction. So company can do it. Board can do it. Right? So Section 185(1) says how company can enter into major transaction. Right? Accordingly, there are 4 ways. The most practical one is the first one anyway. It says, yes, to enter the major transaction, it has to be approved by a special resolution. So company has to pass a special resolution. Special resolutions are passed by the shareholders. Special resolution is what? What's the percentage? Not 51, 75%. 75% shareholders must act. Even as that contingent on approval. Name at that local resource at the approval. 59, in a day, at the past, then it is okay. If not, consent in writing by all the shareholders, 100% capital. Right. Or it must be in the original articles of association. Basically, there's no such provision in the original articles. Amendment articles original article major transaction articles. Therefore, most practical way is that if a company want to buy something, sell something, or if the company want to change its business, then 75% shareholders must agree. Directors cannot do it themselves. So this is a very good protection for the stakeholders of the company. That board has no right. Even though we say that board has a very wide powers, so these are the ways that the law has controlled their wide powers. Right. Right. So therefore, major transaction can only be entered into with the consent of the clear majority of shareholders, not even 51%, but 75%. And with that, we can go to the second part of the lesson, director's duties. Duties of director. So it is first time in Sri Lanka, director's duties are cataloged. Before 2007, they were not in the company's plans. Therefore, our director's duties were decided according to the English common law. English common law duties were the directors of the Sri Lankan directors. They were not free. So from 2007, now directors' duties are written. Anyway, what they have done is they have written all the common law duties now are in written. But anyway, in some section it says, yes, except these written duties of directors, English common law duties are still a part of the Sri Lankan government. So even though we have deviated from the English common law, this is very similar to a Singapore New Zealand system. So related to directors' duties, English common law is still a part of Sri Lankan government. Right. So however, now almost all of them are written. So what do we expect from the directors? If you are director of the government. So if you use the company money for your benefit, what do you think? So now let's say now we have some interview for a director of something. So he's the one candidate. Maybe the board meeting was them. Will you use the term test for improvement for your day? When you come from month. College of hotel expenses. You can't do that. Something else. Will you do it? You can. But if you can, yes, you want to buy a proper, you have some sort of money. So your company has enough money. Will you use it for yourself to buy your land? No. Then you are selected to the board. So you also have a company. So, now when you deal as director of the company, you know that there are some other business, there are company can activate, right? You also are expert of the same thing. You decided to get it personally and get it done without using any company. But what will you do? Will you get it done? Another company's name or you also have my company also have enough money. As a director, you know that if you buy it, the company can make profit. Without using company's money, you can take. What will you do?
Without
Using company's money, using your money, you will buy it. What do you think about that transaction? You will take him to the board of your company. Huh? You? Huh? You know, you can clear a board day the gun other than. Yeah, board day, no, but yeah, then I got nothing or transaction got here on. You can come back at them. Yeah, that's the is also. Board day, no, find it again. Yeah, compare salary here, but then we like salary and tell a transaction again, detail down. Will you take him as a board member of your company or not? He doesn't use any company. It is not a loss to the company. What do you think? Will you take him as a director of your company or not? Yeah, another than the company director. You? Will you take such a person to your company? If not, if it were you. That's funny. Yeah, I got it. But yes, he will do it, right? So therefore, definitely, yes, it's not expected from the directors, right? It's not about the loss and profit. Right? It's your responsibilities. So your duties, your your due care. Right? So we'll see what law expects from a director's duties. But I think Sri Lankan directors are still lucky to some extent because in Sri Lanka, even though there's the director's duties are mentioned, there are no clear guidelines. What are the punishments that the law can do for breach of? There's an example in UK, there's a director's liabilities. Under that it says they breach this duty, this is the punishment. If they breach or break this duty, this is the punishment. In Sri Lanka, there's no such punishment, but still company can sack them from the company and get damages and how those things can be done. But there's no such certain act to make them that. But the director's duties are mentioned, right? We'll see what type of duties the law expects from them. Right? So anyway, those are common law duties. Now they are catalogued. Therefore, I'm not going to discuss the common law duties separately. We'll discuss what is the Companies Act. So what are the Companies Act says about the directors' duties. We all know that the directors are someone like parents. They are like brain of the company. Right. So this is one main duty of the directors expected from the law. This is a common law duty, fiduciary duty. Common law duty was the fiduciary duty. Right. It's still fiduciary duty. It's a duty to act in good faith and in the interest of the company. Duty to act in good faith for the interest of the company. Right. So section 187 says duty of directors to act in good faith and in the interest of the company where he is the director. So therefore, directors are under the duty to act in good faith, right? Where they are in the director. Right? They're going to direct in the company anyway. Sadbalen Katogranda, it will come up. So to act in good faith is a duty. If they do not act in good faith, right, then it's a breach of their duties. Right? So the person exercising powers of performing duties as the of a company shall act in good faith. Shall act in good faith. And in what that person believed to be in the interest of the company. That freedom is given, right? What that person believed to be in the interest of the company. Not what I think, not what society thinks, not what judges think, but what that person believed to be in the interest of the company. Because no believe the directors are business failure. They go to Satbari, make a command, make a band of the student Peter Beach with the Deva, sorry, the Deva, that not right. But you have to be able to justify your thing. Right? You have acted in good faith. If a directors act in good faith, if they can prove it, even though company become bankrupt following day, they are not liable. In company, it is known as a business judgment rule. If there's no such a trader, no one will be happy to take any risk. Right? Loss profit can instrument to the non below, this will get in there, even freedom will live in therefore, if they can prove that they have acted in good faith, then the loss and profit court doesn't. But they have proved that they have acted in good faith. Sadbaring according to what they think. It is known as the business judgment rule. That freedom is given to the board. Otherwise, they never will take a risk. Business is all about taking a risk. Other business but even though laws are still there in some countries, it is very hard to find real evidence. New Zealand, Singapore, so otherwise, they are coming compared to the but you will learn after learning these duties, right? It's a huge responsibility. Right? A huge responsibility. taken implemented. If law implemented properly, no one will be happy to go to it. But so shall act in good faith here again. For their return. Sometimes, even though there's no loss to the company at all, but still law can question your good faith. Therefore, it's a huge responsibility. That's why some countries, it is very hard to find that person to act as the company. However, if they can prove that they have acted good faith, this section related to many other sections, then they are not liable because as a board, they should have freedom to take decisions. Exception के बहुत consider करना है तब नको. Now there is a parent company and subsidiary company. Right? Subsidiary is a fully owned company of the parent company. Let's say B is a subsidiary company, A is a holding company. B is a fully owned subsidiary of A. Now A company appointed X as a director of B company to safeguard holding company's interests. Did you get what I said? Right. Now this X will act for betterment of A company or B company. B කියන්නේ A company के fully owned subsidiary. So A company होगा कारण X appoint करवा as a director of B to safeguard their interests. इतना में X खालू में मेरा कहता है practical, तो ये practical. B में मेरा कहता है A में practical. Definitely, he will act for the betterment of the A company because A company appointed him to safeguard their interests. Definitely, economy. Have acted again. One thing is they have acted in good faith where they are at. Right. Make a practical way that is a director of a company which is fully owned subsidiary of another company may, if expressly permitted to do so by the company's articles, act in a manner which he believes is in the interest that other company. Because otherwise it won't happen. That's practically. Therefore, it's only can be done if it's a fully owned subsidiary. 75%, 50% owned fully owned subsidiary company. With Ratna, even though you are the director of B company, you still can act for the betterment of A company. It has to be a fully owned subsidiary and article must permit it. But there are some cases we will discuss it next week. Okay, next week we can finish this topic and then we can start either research or second. I don't give you any assignment, right? You can do it. We said, I can do it. We say, I'm going to do it. I'm not going to do it. But I want to do it. Go to the listen that way. Listen. Let's see to do one or two more assignment to the okay, then we'll see the next one. Have a big
Yeah, they are